Children.
Children belong to the parents of the All India services.
Rule 3B. Rule 3B. 3B. The rule 3B requires to be read down so as not to include,
Not to applicable, not to insist,
so as to not
to insist,
just a minute, applicable to,
insist.
not to be applicable to children whose
Children's pertaining to
parents
parents of All
parents
India services.
belong to All India services, right?
But I'm reading the, your lordship's a permit, will I'm reading for 1989 3 SCC, page 112. But a similar rule was interpreted. But short judgment I will read so that Lordship will appreciate the facts. And I will ask you. On July 31st, 1987, we allowed the petition directed by the respondent to admit the petitioner. The so-and-so, one of 3 Delhi medical colleges in the first year course prescribed so-and-so course. We said the reasons would be pronounced later. We proceed to do so now. The petitioner was born in Delhi on so-and-so. Her father is so-and-so, was employed in National Council of Education Research and Training. And her mother, the so-and-so, was employed in Government Girls Senior Secondary School. The so-and-so, the petitioner attended the junior public school in Shakti Nagar up to class 2 and Cambridge so-and-so school in New Delhi up to class 92 up to January 1982. Petitioner father was placed on a deputation in January 1982 with the government of Nigeria to serve in its Ministry of Education through Ministry of Home Affairs, Department Personal so-and-so. The government of India, the petitioner who was a minor at the time of it, had to accompany her parents along with her minor brother. In Nigeria, the petitioner continued her education as an overseas candidate and appeared for examination conducted by University of London in Kaduna, Nigeria. And she passed a General Certificate of Education ordinary level, which is recognized by the Central Board of Secondary Education, New Delhi, as equivalent to class 9, class 11 in India. Paragraph 3. On completing the period of his deputation, on April 8, 1984, the petitioner's father returned to India with his family. The petitioner was admitted to class 12 in Delhi Public School, and the Central Board of Secondary Education permitted her admission to that class. The petitioner appeared in All India Senior School Certificate Examination conducted by the Central Board of Secondary Examination, New Delhi.
Now you have supplied this to Mr. Rao, we believe.
Yes. New Delhi in 1985 and passed the examination. The petitioner then sat for entrance examination for admission to one of 3 medical colleges in Delhi, and she obtained 750 marks. The candidates who obtained an equal number of marks or even less were granted admission. The petitioner was denied admission. She fell for consideration in the quota of 70% of seats reserved for candidates who had passed a qualifying examination from University of Delhi, or the Central Board of Secondary Education, or the Council for Indian School Certificate Examination from recognized schools.
Mr. We have read it. This Supreme Court has not declared the provision of particular provision to be ultra vires,
No.
right?
Yes.
And has taken a view that denial of admission because her parents or her father was transferred on deputation to Nigeria, and theoretically speaking, petitioner ought to have stayed in a hostel. That is not always possible. So Supreme Court said that it is denial of admission to her in Delhi quota seat merely on the ground that she has not completed the study in 2 years in Delhi is unreasonable and directed admission. But 1 minute.
Yes.
1 minute. Therefore, the thing is that the Supreme Court, the validity of the provision, we don't know whether was under challenge before Supreme Court. But from the order, it is evident that the Supreme Court has not struck down the rule saying that it is arbitrary. So therefore, one of the possible submissions of Mr. Rao can be that this is an order under Article 142 of the Constitution of India, and your lordships do not have power under 142. So this can be. So how do you meet this?
Yes, I will read the only few lines in paragraph 4. Then I will explain.
No. Whether the provision of rule have been struck down?
No.
It has only been held that denial of admission in the facts is unreasonable.
No.
Correct?
But I will go to that paragraph 4. It seems to us qualifying condition that candidate appearing in the entrance examination for admission in medical college Delhi should have been received last 2 years of education. The Delhi is unreasonable. That is my answer.
It has been held to be unreasonable.
Yes,
But
therefore, not their last say it has
fine. All right.
This
So then what else?
but
So this Supreme Court judgment according to you.
just for my satisfaction, your lordship.
Yes.
But after 6-10 lines.
No, senior counsel, what we always appreciate is, and we are telling it everyone, like if you tell us these are my submissions 1, 2, 3 and elaborate later on, it's very good.
It's not my
So why we are inquisitive is to know what is your next submission, because you only referred to Bombay High Court and now you are reading para 5.
No, but I'm
We
saying.
will read the whole thing, but if you could tell us that my next submission is Bombay High Court, third is like this, fourth is like this, fifth is like this, then you can elaborate.
Yes.
That's better.
My first submission, man. I have already submitted to your lordship.
First submission is that the aforesaid requirement in the rules in respect of parents belonging to All India services is arbitrary and unreasonable. Second submission is such a requirement should not be made applicable to children whose parents are in All India services.
Yes.
And the rule has to be read down.
Yes.
In support of that, you have read this thing. You are relying on 89.3 to say that denial of admission is unreasonable.
Yes, madam. That is the fact.
And other is Bombay thing, right?
But the judgment is not under Article 142.
No, that you can argue, of course. We just told that put you on notice what Mr. Rao can argue.
Maybe, but that.
But if we wanted your response, you will give. What is the second submission? Please tell
My
us.
second submission is this rule, present rule on local area condition cannot be insisted for the children belong to the working in All India services.
That we have noted down. We just now told second submission.
Then the second submission is correct. The rules now they are saying they are not the present rule.
No, just tell us. Then you elaborate, right? We are not saying that we will not hear. So what is the third submission? You referred to some Bombay judgment. What is that judgment?
But I will come to Bombay, but then your lordship, the second my submission is the rules are not framed under the presidential order. The rules are pertaining to local area. B and 3B and small b is not framed under article on presidential order. Article 371D.
Presidential order of 1974.
1974.
Huh?
Yes, sir.
1974.
Thank you.
37-1974.
Huh?
37-1974.
3/7/1974. All right. So therefore,
And therefore, this rules has to, without reference to the presidential order, the rules has to be read down independently.
so therefore rules have to be read down or struck down.
Rules has not struck down. Rules has to be read down independently without reference to the presidential order.
The rules have to be read
Independently
correct indeed.
without reference to the presidential order. But there are that
1 minute.
Article 371D.
Correct.
The presidential order is no longer applicable to the state of Telangana. Presidential order is no longer applicable to the state of Telangana with effect from 2/6/2014.
Two seven 2000 26.
2/6/2014.
Yes. Then next.
Then the next third contention, but the respondents are relying upon a full bench judgment. Full bench judgment.
What full bench? Which
Full bench judgment. 2002 AR 2002 AP 115 is relating to interpretation of the rules pertaining to the presidential order of 2000, what is it? Presidential order 1974.
Therefore of no
This
existence.
judgment is no application. In respect of the students who are seeking the admission. MBBS course for the academic year 2022 and 23. But these are my subjects.
Oh.
So
now,
then I will deal with that.
now this our curiosity is over. You can now read at your leisure.
Yes.
Ah.
Then
That's what we want from any. What are the submissions? Tell, then you can elaborate. You should see we are sitting here to hear you,
Yes.
not to interrupt. But we just have a curiosity.
naturally.
Yes. So what is it? So
Correct.
now we are satisfied.
Your
Now you can elaborate.
My Supreme Court defined you lots was a divine personality. In Bhagavati Prasad case,
Oh.
in Salt Lake, allotment of plots.
Huh?
So
Achha.
all the judges in that,
No.
then naturally you have to hear, but you have to argue the case.
Yes. No, the
Then
only
ultimately you have to
thing.
dispose of the
We
matter.
are sorry to interrupt you only because to know what are your contentions. We
Yes,
have
ma'am.
written down. Now you can go ahead in your own way. We will not say anything. Yes. You
Treat the by,
read the Supreme Court judgment, whatever way you proceed.
what I will read one of the synapses. No.
Yes.
Shall I read, Madam?
Yes. No, this all we have noted down.
No, I am saying the two synapses I am reading.
Acha, that's it. All right.
The petitioner is a minor girl child represented by her father challenging the action of the respondent to in declaring the petitioner as a non-local student in a provisional final merit list of MBBS admission. The petitioner families are from Telangana. The petitioner father is a permanent resident of Hyderabad. He was born in No.1 district. He is a native of Telangana. Petitioner was born in Hyderabad. The petitioner is also permanent resident of Telangana. Petitioner also studied in Hyderabad from class 1st to 10th. Both petitioner parents belong to All India Services. In 2017 and 2020, both the parents of the petitioner were transferred to Chennai in Tamil Nadu. Due to COVID in 2021, the petitioner being a minor girl and dependent on her parents had to accompany her parents out of compulsion. The option of boarding school in Hyderabad was not possible. All boarding schools were shut down during the COVID. The petitioner was compelled to study in 11th and 12th in Chennai. The petitioner, along with her mother and father, occasionally used to visit their houses in Hyderabad. The petitioner will not be treated as a local candidate even in Tamil Nadu. That is very much. The petitioner will not be treated as a local candidate even in Tamil Nadu. The short question which arises in this case, whether respondent number 2 in the facts of this case was justified in treating her as a non-local candidate. The petitioner's case is covered by law laid down by 3-judge bench of the Honorable Supreme Court in so-and-so 1989 TSHC, which deals with the issue of local quota of children whose parents are employed by the All India Services. In Meenakshi case, the petitioner father was employed All India Services, IFS, and was transferred outside the country by Government of India. The petitioner had to complete her education for the qualifying examination outside Delhi, where her father was posted. However, Delhi University refused to treat her as a local candidate for an MBBS admission. The Honorable Supreme Court held that the qualifying condition of Delhi University that students should have studied at least 2 years of education in school in Delhi should be construed to mean to be not too applicable to students or parents employed by All India Services who have to leave the country. The rules are in relevant paragraph and a relevant portion of the law judgment. The rules are intended to be reasonable and should take into account of the variety of circumstances in which those whom the rule seeking the government find themselves. This is the Lordship's opinion. We are of the opinion that the condition in the prescription of qualification for admission into medical college in Delhi, providing that last 2 years of education should be in school in Delhi, should be construed as not applicable to students who have to leave India with their parents, and the parent being posted to a foreign country by the government.
In that case, Nigeria.
Nigeria.
In your case, Chennai.
Chennai transferred Chennai, All India Services, similar to that. Where is All India?
Correct.
Place is different.
We are just telling you to convince you that we have read that judgment
Yes.
cited by you in Meenakshi Malik's case.
Yes.
So that we know that her parents were, her father was sent on deputation to Nigeria.
Yes, but but Supreme Court said, but it is not under Article 140. That is us. But wherever
All right.
the Supreme Court pronouncement was made,
Just a thought-provoking idea for you. Respond. We will see. We don't know what Mr. Rao argues. We'll hear you. Yes.
wherever your worship, the emphasis to all, we are of the opinion the condition of prescription, but this indicates this is not under 142 but 141. But we are of the opinion that condition in the prescription of qualification admission to medical college, providing the last 2 years of education should be in school, should be construed as not applicable to the students who have to live in it. Then the paragraph, the Supreme Court judgment was followed in various court in All India Services. Children's parents, not that children of parents who are in defense services were permitted to seek admission as local candidate. Division bench of Bombay Court in so and so and so and so. B. Children of state government employees were permitted to seek admission to local candidate, irrespective of candidates in so and so judgment, so and so. In case with similar facts of the division bench of Telangana High Court, considered a child of IPS officer, now this honorable court, who was transferred to Maharashtra for the last 4 years to be considered as a local candidate. But the other day I have cited the judgment of the division bench that was finally disposed of. Justice Ramasubramaniam and other lodge. And the paragraph 2, the university has not challenged said judgment before the division bench. Division bench judgment again final.
Where is the division bench?
Entry. But I have already passed the entry model.
Page 100.
The final order is by Lordship Justice.
The final order approves the interim order.
The final order approved the entry model.
Justice Ramchandra Rao. Page 100, Mr. Rao.
Yes.
No, that is not. Justice Ramasubram, not be a pass on the.
Which is where is that? Please
That-
give.
Yes, please.
Ah.
But first I will take the interim order.
31.
That interim order. But second page, Your Worship, the petitioner studied right from the first standard to the higher secondary only in the state of Telangana. But a brief period of 2 years, petitioner is the daughter of the officer belonging to All India Service. Due to the father getting posted in Maharashtra about 4 years ago,
It's going to the same.
Relief was granted. Interim orders proposition will have been made use of. I don't.
Your Worship reading the interim order and final.
Interim order is not a precedent. You have granted an interim order and you are arguing it finally. So there is no read of interim.
I'm saying,
What we are saying is that in compliance of the interim order,
Yes.
in that case,
yes, but
which you have given, the petitioner in that case was admitted and was process of completing first year. Therefore, a division bench of this court said that, I mean, in the aforesaid facts, no cause is made out for disturbing admission of the petitioner. So you are not, we don't know, not completed first year as yet.
no, but that is the facts of this.
That case.
That fact. Therefore, madam, I request you,
Acha, interim order reasons are recorded.
yes, for interim order, Your Worship. Second page, the petitioner cited so and so, higher secondary so and so. Petitioner daughter is an officer belonging to All India Service. Due to her father getting posted in so and so place, the petitioner being a girl was taken for her father for mid study 9th standard, 10th standard in Maharashtra. This is my reason.
Yes.
In cases of this nature, that is my emphasis. In case of this nature, residential qualification prescribed under the second part should be deemed to have been fulfilled. Should be deemed to have been fulfilled. After hearing this interim order that was again confirmed in a final. The final order, Your Worship, say, But
Yes.
but I will read two lines from the final order.
Ah,
In the light of the above said facts, but the facts were indicated, we are of the opinion no cause is made out for disturbing the admission of the petitioner pursuant to the aforesaid interim order, which has been acted and duly sets of justification thereof. That is justification thereof. And therefore, without doubt, 89 Supreme Court was not cited, referred. The principle I put forward in this case. Principle.
we
Then I
continue,
discuss it.
continue after the break.
Yes.
Come in the chamber for 5 minutes. We will dictate whatever is asked. Take this. Bring this. Only bring this. Bring this, and so that we dictate what all is in this also.